Those who may not know me on Zoom or who are present here this morning, my name is Juan Thomas. I'm the chair of the ABA Civil Rights and Social Justice section. Welcome to day 2 of our Economic Justice Summit. For those who were watching online or here yesterday, I hope you enjoyed and gained a lot of knowledge and information about these important economic justice issues. We are so grateful for all of your presence, those who are online and those who are here in the audience live. And so we're having day 2 kickoff with a welcome and remarks from our ABA President, Deborah Enix-Ross. We will play her video shortly. I just want to encourage all of you to continue to engage on these issues of economic justice. And we look forward to collaborating with all of you in the future. We can continue to move our civil rights and social justice agenda forward. So at this time, I want to welcome Deborah Enix-Ross and thank her for her leadership to the ABA and to our section in particular. And after Deborah's remarks, I want to bring up Charles Lowry, the president-elect of the DC Bar here in Washington, and he will introduce our keynote speaker for the morning. Thank you.
Hello, I'm Deborah Enix-Ross, President of the American Bar Association. Thank you all for participating in this Economic Justice Summit. Your presence here and the support of our many sponsors, speakers, and organizers strengthens the ABA's voice for America's legal profession, a voice for professional excellence and a voice for equal justice under law. Let me especially thank the ABA section of Civil Rights and Social Justice and our hosts, the Georgetown University Law Center. The multitude of resources and opportunities provided by the ABA are what makes us the largest, most diverse, and most prominent organization of lawyers in the world. This conference provides what the ABA routinely offers our members, an opportunity to learn from and collaborate with leading lawyers and thought leaders to build our knowledge, hone our skills, and to work together on issues of common concern. Our vibrant, member-driven organization could not serve as the voice of America's legal profession without you and your participation at events like this. I hope you gain new insights from our impressive lineup of topics and speakers. Thank you for your continued outstanding work and dedication that strengthens our legal system and help make justice under the rule of law a reality for all.
Hello, can you all hear me? Good. I'm Charles Lowry, President-elect of the DC Bar, Senior Policy Counsel at the National Housing Council Conference, National Housing Conference. I just started there a few weeks ago. I want to welcome you all on behalf of the DC Bar to the second day of the ABA Economic Justice Summit. I'm happy to point out in terms of working with Paula, working with Marilyn. Marilyn and I met at the ABA mid-year meeting in New Orleans and sat next to each other during lunch. And the idea of coordinating and partnering with you all and for this program came up as we were sitting next to each other. So I want to especially thank Marilyn for bringing the idea and forward, and for Paula and her team for actually making this happen. I hope that everyone enjoyed last night's event at the DC Bar, our new building. If you weren't able to attend, I hope that you'll be able to stop by and visit with us. We have a new building over on 4th Street. It's been paid for by the dues of DC Bar members, and I want everybody to own that and to see that building as a place where they can come and have programs just like we did last night. And now I will go to my job here is to introduce the amazing Zixta Martinez. And I have the distinct pleasure of introducing her. We've known each other a long time, and what I love about Deputy Director Martinez is that she has been at the CFPB from the very beginning. She is currently the CFPB Deputy Director from April 2020 through September 2021. She served as Senior Advisor to the Associate Director for CFPB's Division of Supervision, Enforcement, and Fair Lending. Previously, she served as the Associate Director of CFPB's Division of External Affairs, and before that, she served in the Office of Community Affairs. She joined the Bureau from Freddie Mac, where she was the Senior Director for Industry and State Relations. And before that, she was the Director for the National Fair Housing Alliance, Legislative Staff Attorney at the Mexican American Legal Defense and Education Fund, Housing Policy Analyst for the National Council of La Raza, and Associate Staffer at the Housing and Community Development Subcommittee of the Banking, Finance, and Urban Affairs Committee in the U.S. House of Representatives. She is a graduate of Yale College, the Lyndon B. Johnson School of Public Affairs at the University of Texas at Austin, and the University of Miami School of Law. Director Martinez is one of 5 children raised by her single mom in the south side of San Antonio, Texas. She is a mom to 16-year-old son Julian and an aunt to 8 nieces and nephews. Please join me in welcoming Deputy Director Martinez. He is going to give us some brief remarks, and then we're going to do a Q&A session together.
Good morning. Thank you so much for the gracious introduction. Really appreciate it. And I really am so happy to be part of the American Bar Association Economic Justice Forum, and in particular, the section on civil rights and social justice. We are so glad to be here this morning. The CFPB gains much from its engagement with the legal community. And within the legal community, the ABA section on civil rights and social justice has a powerful and important mission, one that aligns well with the CFPB's own, which is to ensure that consumer finance markets are fair, transparent, competitive, and free from discrimination. Today, I will focus on a key priority for the CFPB when it comes to advancing these goals and promoting economic justice. That is, reining in junk fees. I'll provide an overview of the CFPB's efforts to reduce junk fees by discussing our approaches to overdraft fees and credit card late fees. I will also provide an overview of our supervision and enforcement efforts. And I'll highlight the important role that you, our partners in the legal community, can play in helping us protect consumers in the marketplace. But before turning to junk fees, I'd like to share the latest on our work to support small businesses. Yesterday, the CFPB published a final rule to increase transparency in small business lending, promote economic development, and combat unlawful discrimination. The rule will work in concert with the Community Reinvestment Act, which requires certain financial institutions to meet the needs of the communities they serve. And the increased transparency will benefit small businesses, family farms, financial institutions, and the broader economy. Please go to our website at consumerfinance.gov to learn more about the small business lending rule. Back to junk fees. Let's start with the basics. What are junk fees? A junk fee is any unnecessary, unavoidable, or surprise charge that inflates a product or service's price while adding little to no value. Junk fees have become increasingly common. They include overdraft fees on debit cards, prepaid cards, even fees for government benefits when they are provided through third-party servicers. Junk fees hurt consumers across the board, and they hit certain populations especially hard. A report by the Federal Reserve Bank of Boston found a higher percentage of Black Americans pay overdraft, non-sufficient funds, and credit card late fees than white Americans. The report also found that low-income Americans are more likely than high-income Americans to pay overdraft fees. The infiltration of junk fees into consumer financial markets did not occur overnight. Many of these fees started out as a normal means of providing popular services or covering a business's incurred cost. People are willing to pay for legitimate services at reasonable prices, but they're not willing to pay for unexpected or unwanted services. As the CFPB began to root out junk fees, we identified the prevalence and magnitude of banks' reliance on overdraft fees and the related non-sufficient funds fees. In 2019, the average cost of an overdraft or non-sufficient funds fee was between $30 to $35, bringing in more than $15 billion every year for banks. And perhaps more egregious, we found that a significant portion of this profit came from charging customers unexpected surprise overdraft fees. After identifying the extent of the problem, the CFPB acted. In October of 2022, we released guidance to protect consumers from these illegal practices, and we have held two major financial institutions to account: Wells Fargo and Regions Bank. Here's some good news. Our efforts to identify junk fees, warn institutions, and enforce against these practices are seeing results. As of today, 20 of the country's largest banks, which hold 62% of the volume of consumer deposit accounts and are subject to the CFPB supervisory authority, now do not charge surprise overdraft fees. In fact, our research has shown that between Q1 of 2019 and Q1 of 2022, some of the country's largest banks saw double-digit percentage drops in overdraft and non-sufficient funds fee revenue, with one institution seeing a drop of over 50%. Perhaps most notably, the loss in overdraft and non-sufficient funds fee revenue is not being made up through charging customers other fees. In other words, financial institutions generating profit through junk fees is not inevitable. We will keep tracking the data to better understand how our policy interventions are helping consumers. And we are eager to hear from stakeholders about how banks continue to use tricks and traps to harm consumers. I'll now turn from overdraft and non-sufficient fund fees to another kind of junk fee that has skyrocketed from a small corner of the market to the top of everyone's least popular junk fee list: credit card late fees. These late fees are big revenue generators for card issuers. Credit card companies charged $12 billion in late fee penalties in 2020. That comprises 10% of total credit card interest and fees paid by consumers. And that revenue comes disproportionately from people living in low-income neighborhoods. It wasn't supposed to be this way. In 2009, Congress overwhelmingly voted to pass the Credit Card Act to reform the credit card industry, clean up widespread abuses, and ban unreasonable penalty fees. The Credit Card Act allowed for fees that are reasonable and proportional. For credit card late fees, that meant fees that covered credit card companies' collection costs for missed payments. In 2010, the Federal Reserve Board, who was responsible for writing the rule to implement the Credit Card Act, included a credit card late fee immunity provision in its rules that permitted credit card companies to escape enforcement of scrutiny of reasonable and proportional fee requirements, even if a company charged credit card late fees beyond collection costs. The Federal Reserve Board also allowed credit card companies to hike the fees annually for inflation. The inflation provision permitted a maximum late fee to jump from $34 in 2009 to $41 now, a nearly 21% increase. And the immunity provision has allowed the increase with no change in scrutiny of the fees. The CFPB inherited the Federal Reserve Board's credit card late fees rule, and in February, we published a proposal that reimposes the reasonable and proportional guardrails that Congress passed. We proposed lowering the immunity provision to $8, which our research shows to be the average collection cost. We also proposed that credit card late fees cannot exceed 25% of the required minimum payment. And we also propose to end the automatic inflation hike. The rule is fair to credit card companies because the proposal would permit credit card companies to charge late fees above $8, but credit card companies would have to prove that their fees are in line with the collection cost. Comments are due May 3rd. As we consider this and other rulemakings, it is vital that we hear from you, our stakeholders. We need to hear consumer stories. We need their voices as people who often work directly with those affected by unscrupulous practices and fees. Your insights and connections with impacted consumers and communities are invaluable. We are seeing signs of increased competition in consumer markets. However, some institutions still charge unlawful junk fees. And to be clear, these extend beyond just surprise overdraft and credit card late fees. For instance, junk fees are often charged in situations where consumers have little choice in the firm, provider, or processor with which they must do business. For example, CFPB examiners have found that some mortgage servicers charge unlawful and sizable phone payment fees, even though consumers were not made aware of these pay-by-phone penalties. Following these findings, the CFPB required the servicers in this instance to reimburse all homeowners who paid phone payment fees when those fees were not properly disclosed. In September of 2022, the CFPB exercised its enforcement authority and ordered Regions Bank to pay more than $190 million in customer redress and penalties for surprise overdraft fees. The CFPB will keep working to identify the practices that enable unlawful junk fees and uncover the underlying financial reasons financial institutions implement these processes instead of making the choice to compete on fair terms, where we can work with companies through supervision to get them to change practices and make harmed consumers whole. We will. But we will not shy away from exercising enforcement authority against egregious or repeat offenders. It's important for consumers to know that one way we identify illegal activity is through consumer complaints. I encourage you all to inform consumers about the important role they play in identifying and ending unlawful junk fee activity. Before I close, I would be remiss not to mention the litigation involving the CFPB, which is before the U.S. Supreme Court in connection to the Bureau's payday payment provisions rulemaking. As the U.S. Solicitor General lays out in our cert petitions, which I encourage you to read, the CFPB's funding mechanism is not novel nor unusual. As it did for the Federal Reserve Board and other federal banking regulators, Congress authorized the CFPB's funding through legislation other than annual spending fees. The type of funding is vital to the nation's financial regulatory system, providing stability and continuity for agencies and the system as a whole. Perhaps most importantly, Congress has appropriated the majority of the overall federal budget, including Medicare and Social Security, through non-discretionary or mandatory spending that, like the CFPB's budget, does not go through the annual spending bill process. So the potential ramifications of this case extend well beyond the CFPB. Last week, a unanimous panel of the Second Circuit affirmed a district court's decision enforcing a civil investigative demand to investigate potential violations of laws under our care. Importantly, the panel addressed issues related to the CFPB's funding structure and the Fifth Circuit's decision in the payday rule matter that will be reviewed by the Supreme Court. The panel's opinion offers this explanation for why the Fifth Circuit's decision is problematic. Quote, as a threshold matter, we cannot find any support for the Fifth Circuit's conclusion in Supreme Court precedent. Likewise, we find no support for the Fifth Circuit's reasoning in the Constitution's text, nor do we find support for the Fifth Circuit's reasoning in the history of the Appropriations Clause. end quote. Rest assured, CFPB will continue to work closely with the Department of Justice as the Supreme Court prepares to hear the case. In the meantime, we will continue the vital work Congress charged us to carry out on behalf of the American people. Thank you for inviting CFPB to be part of this year's Economic Justice Summit. I understand Charles has some questions that he'd like to pose.
Thank you. Thank you, Deputy Director. I have this first question is a general question, and I'll just give it to you. Given your time at the CFPB from the very beginning, we wanted you to just tell us the current state of predatory lending practices. You mentioned the junk fees, and we'd like to hear more. The CFPB's position and outlook on the ability to repay principal for loan determination process purposes, and your thoughts on consideration of expansion of protections under the Military Lending Act for all consumers.
Thanks, Charles, for that question. And you were correct. I did witness the various iterations that occurred to our ability to repay rulemaking, in particular the payday rule, which was published in 2019 under then Director Cordray and rescinded in subsequent years under the previous administration, and is currently, in fact, the subject of the Supreme Court case that I mentioned. We have been very public about how critical this issue is to communities. As you said in my introduction, I grew up in Southside San Antonio. You can't go a block without running into payday lenders, pawn shops. It is readily available at the taking. We made significant progress when we promulgated that ability to repay rulemaking. And what we have said is that we will use every tool at our disposal to continue to monitor that market. We have also signaled that we would not be engaging in legislative rulemaking at this time. But you may, if you follow the CFPB, you're aware that we've brought several enforcement cases on the matter. It is an issue that has affected me personally and my family. It is an issue that the staff at CFPB are passionate about. So we monitor that market very closely, very intentionally. With respect to the Military Lending Act, there too, we've brought enforcement cases and we monitor and supervise for that law as well. With respect to extending the interest rate caps that the MLA offers to service members, as you know, that would require a congressional act, as our statute doesn't really allow us to touch interest rate caps. So stay tuned.
Thank you. Our second question, with Silicon Valley Bank and all the issues around fintech, we wanted to know your view of the status of challenges of new fintech products in protecting low-income consumers, such as buy now, pay later, earned wage access, or training repayment agreement provisions, and those types of products.
I like the acronym for that.
Right, traps. Yes.
With respect to buy now, pay later, BNPL, we, as you know, issued a series of orders to 5 companies offering buy now, pay later credit to collect information about the risks and benefits associated with this fast-growing slice of the market. We are continuing to monitor and provide transparency to the market. We have concerns, and I would say there that we will continue to be vigilant there as well. With respect to earned wage access products themselves, you may be aware that there was an advisory opinion issued in November of 2020, which, based on our assessment, we believe has not really afforded clarity and in fact has caused considerable confusion about credit and earned wage access products. So what recently, GAO also published a report that recommended that we consider extending the truth in lending definition of credit to earned wage access products. It's a recommendation with which we agree, but there's more work to be done. We are doing that work, so there too, stay tuned.
Okay, thank you. Now, we've covered a number of topics, Deputy Director. We're interested in an update on debt collection abusive practices and the thoughts behind weak state laws that have created large areas of harm for consumers. Are there any initiatives at the CFPB or ongoing initiatives to address this matter?
Yeah, well, recently we issued an advisory opinion to address precisely that issue, the pay-to-pay fees by debt collectors. This is one of those junk fee issues that I noted. Our advisory opinion stated that the collection of any fee is prohibited unless the fee is in the consumer's contract and explicitly and affirmatively permitted by law. We've been very focused on medical debt collection. We've made several advances there. We issued a bulletin last year to prevent unlawful collection and reporting in unpaid medical bills, and we believe that there's been significant positive impact to consumers. As you know, that is a very heavy debt burden to many consumers. So we think it's important to be clear about what is permissible to be collected and what is not, and what is and the impact to consumers' credit reports associated with those types of activities. So more to come on that, Charles.
Come on that, okay. And now finally, our last question, Deputy Director Martinez. What is the CFPB doing to address discrimination and unfair lending and consumer practices through the use of artificial intelligence algorithms or automated decision-making tools? The chat bots and things like that are becoming the rage. People are been talking about that. I think there was a segment on 60 Minutes I saw about AI. So could you help us with that?
I mean, I think it's tempting to think that machines crunching numbers and considering our data in very complicated ways can take bias out of the equation and decision making, but they can't. So we've done a number of things in this area. We've continued our traditional bread and butter anti-discrimination work. In redlining, we've brought 2 cases. That continues. But with respect to this new type of discrimination, we've issued circulars to other federal agencies confirming that federal anti-discrimination law requires companies to explain to applicants the specific reasons for denying an application for credit or taking other adverse actions, even if the creditor is relying on credit models using these complex algorithms. That means you can't say, oh, ABM said. You actually have to be specific and afford the consumer that information. We've also published an advisory opinion to affirm that ECOA bars lenders from discriminating against consumers after they received a loan, not just during the application process. And as you know, yesterday we finalized our small business lending rule, which we believe will bring greater transparency to how small businesses are treated. Small businesses are often just a single individual, and the barriers that they face to get credit to ensure their business succeeds are often very similar. We're also actively participating in government-wide efforts to promulgate rulemaking addressing ABA as well. We are hopeful to get that over the finish line soon.
Okay. Well, I thank you, Deputy Director Martinez. It's been great to have you speak to us. I think that I believe that Deputy Director Martinez is an advocate, and she's been at the CFPB from the very beginning. She is doing a great job, and I'd like you all to join me in thanking her for her presentation.
Thank you, Charles. Thank you, everyone.